Good morning, everybody. Thank you for coming to the third in the series of Understanding Patents. I am Jason Wong Sam, the Assistant Patent Manager here at JIPO. And this morning I have with me Mr. Rolando Hernandez Vigad, who is a national of Cuba and Switzerland and is currently working at the World Intellectual Property Organization, WIPO, head office, right? In the service section of the Patent Corporation Treaty, right? He has been there since 2000, the year 2000, Mr. Hernandez. That's wonderful.
Yes. Well,
And right, and he as the senior programs officer and in the developing countries PCT division, right? And he is here today with us to speak to give us insight on the PCT, which is a very integral part of our new legislation. So this feature will allow you to stay in Jamaica and file patents around the world. And I think it's very useful. It will be a very useful tool for Jamaicans as well as anybody who is interested in the patent field to come and know how to do this, because I think we are a central point in the Caribbean. So I think it is very important. So without further ado, I would like to turn over to Mr. Hernandez. Welcome, Mr. Hernandez, and thank you for being here.
thank you, Jason. Good morning, everybody, and thank you for having me and being here because this topic is going to be really important for you in the very near future, I hope. For those who participated in the webinar we did last year in September, unforgettable for me because it was my birthday. You are going to see some of the slides I presented, but this time I will try to take you on a journey through the whole PCT system. The PCT itself is not a very passionate subject matter. Actually, it's quite boring because it's a very technical and full of legalistic points treaty, but still it's very important to know what is there, how we can use it, and how also we can judge the information that is provided by the PCT system. I'm going to share my screen. Can you see my presentation?
Yes, we can.
Okay, thank you. No, because in my screen I cannot see anything. Well, let's start with the basics, the introduction to the system. The system of the PCT system, the Patent Cooperation Treaty System, is based in the traditional patent system. The traditional patent system, as some of you may know, is the foundations are in the Paris Convention for the Protection of Industrial Property. In the Paris Convention regarding patents, an international cooperation system was established at the end of the 19th century in a way that one applicant can file an application locally, and this applicant has 12 months to file the application in other countries with the recognition of the date of the first filing as important advantages. That is called the priority in the Paris Convention system. This system, I told you, it was adopted at the end of the 19th century, so it's so old already, but it has good advantages for applicants, but it also has many disadvantages. In that way, the applicant have to monitor different patent system, different dates, different formality requirements, and the process of getting a patent in every jurisdiction becomes quite complicated because of the multiple deadlines that he has to face in every country. So what the PCT system did? The PCT system was born in the 17th last year. It entered into force in 1978. And what he does is to establish an international cooperation system. That's why it's called Patent Cooperation Treaty, that allows applicants to file an international application instead of many national applications in the in the timeline of 12 months from the first filing in the country of origin. It is also based, the PCT system is also based on the Paris Convention, but it tries to alleviate some of the disadvantages that applicants can face during the Paris Convention uh, processing of their applications, in a way that applicants have to face only one set of formality requirements, and the international procedure, as we are going to see in the next minutes, is designed in a way that applicants can get the maximum information, technical information about the application they are trying to protect, to better take decisions as far as protection is concerned. This is a comparison between the traditional patent system, the Paris system, and the PCT system. The advantage is not only in terms of time. As you can see in the Paris traditional system, applicants have 12 months to file application abroad. In the PCT, these 12 months are extended up to 30 months from the priority date. But also, the one important advantage of the PCT system is, as I just mentioned, the information factor that you don't have in the Paris Convention system. In the PCT, you are going to get information all along the procedure that will allow you to take better decisions concerning the protection of this invention you are trying to get. There are some very important ideas that dominates the whole logic of the PCT system. The first thing is the PCT is a patent filing system, not a granting system. We have no PCT patents. We have no international patents. There are international applications that if they are lucky, they are going to end up being national patents, but not PCT patents. In the PCT system that we are going to see soon in the graphics, we have two main phases, the international phase and the national phase. But please keep in mind that the final decision concerning the granting or not of a patent is exclusively taken by national offices. There is nothing in the international procedure that prevents national office to apply their own legislation when dealing with a patent. Obviously, as the name indicates, the PCT system is only for inventions, to protect inventions. They can be protected by patents, utility models, or similar titles, but not trademarks or designs. For that, we have different treaties at JIPO. In the case of design, we have the Hague Agreement. In the case of trademarks, we have the Madrid system that are intended to deal with these modalities of the intellectual property. And here we arrive to the timeline. This is going to be our line for today. We are going to follow this in my presentation. And well, it represents the main steps of the PCT procedure. You can notice here that in this PCT timeline, I'm showing you that first the applicant file a national application, and in 12 months he files the PCT application. This is not the only way of using the PCT system. You can file the international application as first application without claiming priority. But most of the applicants use this way. That's why we are using this as an example, because more than 80% of the applicants prefer first to file a national application in their own country, and then in the 12 months period, file in an international application to start the PCT procedure and seek protection in other countries. So as I told you, we are going to try to do it like a bus journey as the PCT. The beginning is always have to be always the first stop is the PCT filing. And in the PCT timeline, you see the PCT filing is this area in the red square. It's the first act that the applicant do to enter into the PCT procedure. So, what is to be filed? What we have to file to start the PCT international, the PCT procedures and international application. This is only one international application. We don't need to file as many as international applications or countries of interest we have. With filing one international application is enough for the whole PCT system. This international application automatically designate all member states of the PCT that nowadays are 153. So if you file one international application, you are filing simultaneously in the 153 member states. With the fact that this international application has the effect of a regular national filing in each designated state. By default, when you file an international application, we consider that you are filing for the protection of a patent. But you can say, no, I don't want a patent, I want a utility model. You can say it during the international phase or later when you enter the national phase. The international application has to be filed in only one language. In the case of Jamaica, it will be English. That is the most common used language in the PCT. And it's going to be filed with only one office. So you have to file your international application in what we call the receiving office. That's why we write there RO, the receiving office. The receiving office is the national office, the same national office, in this case, the Jamaica Intellectual Property Office, when Jamaica joins the PCT, that will act as receiving office. And the filing in that office is good enough for the rest of the offices. That's why this is an international cooperation system. The formalities is an important advantage for applicants. We will require you only one set of formalities. And this set of formalities is good not only for the international phase, but also has to be good for the national phase, because no member state will be allowed to ask you more formalities than the ones that are already in the PCT. And well, the filing of the international application delays the national processing up to 30 months from the priority date. That's we have seen, and is the time advantage of the PCT. Now, who can file an international application? Who can be the PCT applicant? The applicant can be a natural or a legal person. It doesn't matter. The only requisite we request is that this applicant, or at least one of the applicants, must be a national or a resident of a PCT contracting state. If there are 10 applicants with one that fulfill this requirement of nationality or residence in one contracting state, is enough. There is no need that all applicants be nationals or residents. Only one is enough. When Jamaica joined the PCT, obviously, before JIPO as receiving office, all Jamaicans will be able to file international applications, but also foreigners that have legal residence in Jamaica, because they are entitled also to file before the national office as receiving office. However, I have to tell you that applicants have always at least two options as where to file the international applications. The one I already mentioned is the national office. The national office is the receiving office where we can file international application. But also all applicants from all PCT member states are entitled to file with the International Bureau of WIPO here in Geneva. The International Bureau acts as receiving office for all applicants in every language. But that's the applicant who have to decide where to file. Normally, it is easier and more convenient for the applicants to file in their own office because, of course, you will have the same time schedule. Maybe you will find somebody that helps you to do the processing of the application, etc. But still, there are many applicants that choose to file with the International Bureau of WIPO. These are I'm going to talk about later. What are the elements that makes up the international applications? There is a list here that if you read it, you can see they are more or less the same elements that make up national applications. When you file a national application with the Jamaica Intellectual Property Office, you have to file a request, a description, claims, abstract, drawings, and sequence listing, etc., depending on the nature of the invention. These are the same elements that make up the international application. There is not big difference. There are other elements that may accompany the international application. For instance, if a translation is needed, that is not going to be the case of Jamaica, because as I told you, English is widely accepted in the PCT. But for instance, the power of attorney can be needed. So it has to be filed along with the international application. But for the purpose of the system, they accompany the international application. They are not part of the international application. The same happens with the priority documents, the indications concerning biological material, sequence listing, etc. And you may ask why there is this difference between these elements that make up the international application and this element that may accompany the international application. And the difference is very simple, it's money. Why? Because in the PCT we are going to see it later, we have an international filing fee that is for applications up to 30 pages. If the application has more than 30 pages, the applicant will need to pay a fee for every additional page. But this fee is only applicable for the elements that make up the international application. For those elements that may accompany the international application, there is no payment. So you can file the power of attorney, the priority document, etc., without fear of increasing your fee. The fee is going to be the same when you attach these documents. Now, how to file an international application? Obviously, the classical way of filing an international application is paper. But I have bad news. Only 2% of international applications are filed on paper. Most of the international applications, up to 98%, are filed using electronic means, mainly the ePCT filing tool. That is a system that is administered by JIPO, which allow applicants to file the international application directly from your your workstation at home or at your office. And this has also other advantages like fee reductions if you file electronically, and it's way more easy to file electronically than to file on paper. The filings on paper will always be allowed, but we really encourage applicants to use the electronic filing because in addition to the fee reductions, etc., and the speed and the savings you made, because you have no cost of paper, of courier services, nothing like that. The ePCT filing is foolproof, meaning that there is a lot of incorporated test-in facilities that are going to guide you every step of your filing and tell you if there is a mistake, if there is something that will affect your international application. So it's very easy to use. I always say that in our days, if you use Facebook, Instagram, and these things, you can use ePCT. It's way easier than Facebook. So I invite you to take it into account when thinking of filing international applications. There is the issue of agents and common representative. What are these in the PCT systems? Well, who can act as an agent? Any person that has the right, according to the national legislation, to practice before the receiving office can also be an agent during the international procedure, the PCT procedure. So here is the national law that apply. If you are entitled to represent before the Jamaica Intellectual Property Office, you are also entitled to be the agent in the PCT procedure. Now, we know we do need to have a contact point for every international applications. And sometimes there are like 3-4 applicants, and it's difficult for us to deal with that. If there is an agent, no problem. We communicate directly with the agent. But if there is not, the applicants have not nominated an agent, there is no agent, then we need only one contact point. And this is what the PCT has created as the common representative. What is the common representative? One of the applicants. The common representative can be nominated by the rest of the applicants. But if they don't decide or they don't say anything about who is going to be the common representative, the first one that appears in the application will be considered by us as the deemed common representative, just for the communications and so on. Well,
Excuse me, Rolanda, your sound seems to have gone away.
now it's okay? Yes, I think.
Yes, we're good.
Thank you. Sorry for that. Well, I was saying that we have already filed the international application. That was our first stop. The international procedure has started. The international phase, the PCT international phase has started. And then this application is going to be regulated by the PCT and not by the national legislation. And the second stop is a very important stop for the applicant, and that is the international search and written opinion of the International Searching Authority. In the PCT, we love acronyms. You see here, we use ISA, that's International Searching Authority. In the PCT timeline, again, in this red square is this step, the International Search Report and the International Written Opinion of the ISA. Once let's say that Jamaica is part of the PCT already and you have filed an international application with the JIPO as receiving office under the PCT, what the office will do? Well, the office will send a copy of this international application to the International Bureau and will send another copy of this international application to what we call the International Searching Authority. Which are the international searching authorities? The international searching authorities are national offices that have acquired, to say it in some way, the status of international searching authority because there are certain requisites that they have, but they have to demonstrate it, and the nomination is made by the assembly of all PCT member states. As you can see, we have 23 international searching authorities. All of them work in English, absolutely all of them. And so you have the choice. When a country joins the PCT, the receiving office, in this case, the Jamaican Intellectual Property Office, will decide out of these 23 international searching authorities which one are going to be competent for applications filed by national or residents of Jamaica. The Jamaica IP office can decide that it's only one, that are 2, 3, 4. We have offices that have designated like 7 international searching authority just to give plenty of options to applicants. When the applicant files the international application, he has to choose amongst these international searching authorities that are competent for him or her, which one they want to use. Let's say that Jamaica has decided that for applications filed in Jamaica, Canada, Japan, and US are going to be competent, just to mention 3. So in the moment of filing the application, the applicant has to say, I want to use Canada, or I want to use Japan, or I want to use US. He can choose only one out of the ones that are have been chosen by the national office. And what the international searching authority does. First, it checks unity of invention. That is a common requisite in all patent laws. Check the title, checks the abstract to see if they are well characterized, taking account the description and the claims. But the main function of the International Searching Authority is to do a search of the invention. What is to do a search? What I mean when I say that the International Searching Authority is going to perform a search of the claim invention. They are going to look in all written documents published up to the moment of the filing of these international applications that are related in one way or the other to this international application. meaning that they are going to explore what we call the state of the art. I mean, everything that has been published, being a patent document or not, that concerns what is included in the claims of the inventions, in order to provide the applicant with a list of documents that are already in the state of the art, that can affect the patentability of this invention, taking into account the novelty and the inventive step. This information is published, this list of documents is published in what is called the International Search Report, that is produced by the International Searching Authority. But at the same time that the International Searching Authority produce the International Search Report, they are going also to send, along with the International Search Report, what is called the written opinion. What is the difference between the International Search Report and the written opinion? As I told you, the International Search Report is a list of documents that has been published and are in the state of the art. But there is just a list. The International Searching Authority is not going to tell you in the International Search Report if your invention has novelty or has inventive step. This is going to be dealt with in the written opinion. In the written opinion, that is a non-binding opinion, and I underline the word non-binding because it's just for information. It's just to give some tools to the applicants to decide, but it doesn't oblige national offices to grant the patent later. You can have a perfectly brilliant written opinion, but then when you enter into a national phase, the national office will tell you, no, I will not grant the patent because of this or that. So the written opinion is the opinion of this examiner concerning the novelty, the inventive step, and the industrial applicability of this invention that you have filed in the PCT procedure. These are two different documents produced by the same authority with over the same invention, with the same subject matter. But the focus is completely different. One is documental information, I mean, documents that have been published, and second is the opinion of the examiner concerning the patentability requirements, novelty, inventive step, and industrial applicability. Once you have this or this international search report and the written opinion, there is something that I have to show you in the from here. I think that was talking about. Well, I mentioned it already. No problem. So I was telling you, you have filed the international application. The international application has been subject to international search and international and the written opinion. The International Searching Authority has sent you these reports, both the search and the written opinion, for your in order you to assess the potential of the invention, taking into account what has been published in the state of the art. And then the third stop arrive, that is the international publication. It is here in the PCT timeline. You see it is immediately after the international search report and the written opinion. These three first stops that I have or I'm about to finish to explain, the PCT filing, the international search report, and the written opinion and the international publications are mandatory. All international publications have to be subject, first have to be filed, secondly have to be subject to the international search report and written opinion procedure, and then have to be published. These three steps are, again, mandatory, and that's important to know. So what is the international publication? The international publication happens at 18 months from the priority date. And it normally international applications are published in the language of filing. If you file in English, the international publication will be published in English. But for those international applications that were not filed in English, the title, the abstract, and the search report will always be published also in English, just to facilitate the use of the patent documents that are published by the International Bureau. The international publication is available only in electronic format in this address here in the patent scope database at JIPO, and is made by the International Bureau. Every Thursday of every week, we do the international publication of those applications that are about to have 18 months filed from the priority date. What is the contents of the international application, of the international publication? Sorry. There is a front page with all the bibliographic data, the abstract, meaning the name of the applicant, the agent, when it was filed, etc. The abstract of the invention, and if there are drawings, on one drawing is always also to be published in the front page. This front page is followed by the full text of the description, claims, and all drawings, plus the international self-report. The international self-report is published along with the written opinion. The written opinion is not here in this slide because, legally speaking, it is not published. It is made available to the public. But for practical purpose, it is published like everything else. It is in the patent scope database that is free to use and is always there. This is information that is useful, obviously, for the applicants that can make or advertise their invention in patent scope. It's useful also for national offices, but it's also very useful for third parties that can use the international publication for infringement procedures, etc. As I mentioned, I'm checking also the questions that are in the chat, but it's okay. As I mentioned, the international publication happens at 18 months from the priority date. But there are cases that mainly for commercial purposes, applicants want to have the publication early. So they can request an early publication to the International Bureau. This can be free of charge or not. It depends. If the international search report and the written opinion are already available, we do the early publication with no cost. But if the international search report and the written opinion are not still ready to be published, then we do an early publication of the international application alone, and then we republish it once the international search report and the written opinion are ready. And in this second case, a fee have to be paid. Well, I told you the international the publication is only published, only happens in electronic format. We have left out paper years ago and are available in patent scope. All publications, more than 3 million international files since the very beginning of the PCT are published in patent scope and you can see all documents related to the application that I told you. What is the effect of the international publication? And this is important to keep in mind. The main effect of the international publication is that this application become part of the prior art as of the international publication date. As you know, most of the, no, or no most, all patent applications are kept confidential by the IP offices because this is a very sensitive matter and it's not published anywhere. So up to the moment that the publication date arrive, they are kept confidential. But once they are published, they are part of the state of the art. And once you are in the state of the art, you cannot go back. You are forever in the state of the art. So this is important because sometimes applicants want, because of the international self-report of the written opinion, they want to improve the international application, the technical content of the international applications to avoid interference of the prior art. But to file it again, you have first to stop the publication. And the only way of stopping the publication and stopping this technical content to be part of the prior art is withdrawing the international application or the priority claim. These are very complicated procedures, but for now, just know that they are available because the patent itself is not an end, it's a means to an end. And normally the end is related to trade, to commerce, to profits, to dominate markets, to sell some product or service in advantageous position. That's why it is so important to keep novelty and inventive step, but mainly novelty of the products of the invention we are trying to protect. And that's why if we want to change, to improve, to do something different with our international application, it's important not to publish it, but just to withdraw it and then file it again with all the additions or improvement we were able to make and let the procedure take the application with the new content being more successful. Because once it is published, even if you are the same applicant, it doesn't matter. It's already in the state of the art and your novelty is destroyed. And that cannot be avoided. It's something that cannot be taken back. So as I say, these three main steps, filing an international application, international search and written opinion, and international publication are mandatory. Now we have the fourth step that is optional and is the supplementary international search. And this is here in the PCT timeline. What is this procedure of international supplementary international phase? You know that nowadays there are certain technical fields that are extremely dynamic. Just to quote one, the communication technology, all that is mobile, 5G, etc. You can see improvements and new things every single day because it's a sector that is very profitable. Everybody uses it, and there is a lot of competition. So sometimes when dealing with international applications related to these dynamic sectors, applicants can have concerns about the prior art found in the international search report. When they have this concern, they can request a supplementary international search report just to be sure to cover more geographical areas, maybe. It happens also that if you see the statistics of patent filings in the last years, the area of the world where the patent filings and international filings are growing by 15, 16% is in Asia. But this has a problem. In China, they speak Chinese. In Korea, they speak Korean. And in Japan, they speak Japanese. That are languages that are not easily accessible. The information, the technical information published in Japanese, Chinese, or Korean is not easily accessible because of the language barrier. So this international supplementary research can help to solve this problem. For the time being, there are only 10 international searching authorities that offer this service. You see Austria, the European Patent Office, Finland, Russia, Sweden, Singapore, Turkey, Ukraine, the Visegrad Patent Office, and the other one I don't remember. XN is the, I don't know. Well, I'll tell you later. It will come. So the success of the international supplementary research service is not really big. Not many applicants use this because of the limited scope of the international searching authority that are offering the service, but also because of the international search itself has increased the quality. So there is not really need to request for another search that obviously is going to add an additional fee to the load of money you have to pay for using the international procedure, because all of these steps require the payment of fees. This is, I show you already, the supplementary international search in the PCT timeline. And there is another stop that is could be the second or the third, this that because it's also optional, that is the international preliminary examination. This used to be very popular many years ago, but now it's not that popular because, again, you have to pay fees if you want to use the international preliminary examination. And it's mainly used for applicants as part of the strategy when the international search report and the written opinion is not really good. The result of the international search report and the written opinion are completely negative for the applicant. So in that case, the international preliminary examination procedure represents an additional opportunity to try to save the international application, introducing modifications and changes in the application. Here is the international preliminary examination in the PCT timeline. This is not really exact that this is the third of the fourth stop, because you can file an international supplementary search or an international preliminary examination. It depends on the will of the applicant. In good practices, you will never file both because you are spending a lot of money, and the results, although can be quite different for you as applicant, are going to be more or less the same. Depends on what you want to achieve. And what is the international preliminary examination? What is is very similar to the written opinion, but with some difference, because here the international preliminary examining authority, that are the same international searching authorities, will establish a non-binding opinion on novelty, inventive step, and industrial applicability. So what's the difference with the written opinion? Here, first, before starting the procedure of international preliminary examination, you have to answer the problems that were detected during the international search and the written opinion. For instance, if in the written opinion the examiner tells you that according to his knowledge, the claim number 5 of your application is not novel because of this, that, or that, because it has been published before by another company or by yourself, then if you request an international preliminary examination, right in the moment of filing the international preliminary examination demand, you have to file a set of documents answering this problem that was um, included in the written opinion. How do you answer the problem? Well, you can modify your international application, for instance, removing some claims that are in the state of the art, or you can modify the technical content of the international application just to try to avoid this prior art that was quoted in the previous in the written opinion and the self report. Another possibility is that you strongly disagree with the opinion of the examiner. You think that the prior art that has been quoted by him has nothing to do with your invention. In that case, you present arguments to the International Preliminary Examination Authority just to try to convince them to that your invention deserves to be a good report and deserves to be protected. So, in a nutshell, the international examination provides an opportunity to make amendments and to address patentability issues raised by the International Searching Authority. Important to know that only those claims that were subject to international search can be subject to international preliminary examination. So if for any reason the International Searching Authority say, no, I'm not going to perform any search concerning these claims because of morality, let's say, well, in this case, these claims are not going to be subject to international preliminary examination. This doesn't affect the international application. The international application keeps going alive in full, but just for information, you will not have a technical opinion on those claims, either in the search or in the preliminary examination steps. And now we are going to talk about fees. That, as I told you, is an issue that is important for applicants. I'm trying to show you the latest fees in the PCT. Here they are. So, where is my screen now? Here. So, what are the fees that have to be paid in the PCT? When you file the international application before the receiving office, you have to pay. You see that there is a list of many fees, but you will, in principle, have to pay only the 3-4 first fees, the one that are in bold letters. That is the transmittal fee, the international filing fee, the search fee, and the supplement per set that in excess of 30. The transmittal fee is a fee that is not equal for every office. The transmittal fee is established by the receiving office and is for its own benefit. So I cannot switch both screens. Later, I will show you all fees because if I abandon this, I cannot use both at the same time. Then there is another fee that is the international filing fee. The international filing fee is equal everywhere in the world. And in this moment, the international filing fee is 1,553 US dollars for every international application. This international filing fee is paid to the receiving office, but is for the benefit of the International Bureau of JIPO for managing and coordinating the whole PCT system, including the cost of international publication and communication with all national offices. The search fee is the third important fee that you have to pay at this step, and is a fee for the service rendered by the International Searching Authority, namely a fee to pay for the international search report and the written opinion. The search fee, again, is not universal. Every international searching authority establishes his own fee and its own fee reductions that are different in different countries. And then, as I mentioned before, if the elements that make up the international application exceed 30 pages, then you have to pay a supplement for every page that exceeds 30, from 31. And this is for the International Bureau and is supposed to compensate the cost of the international publication, because if longer, as long as it gets, is expensive to publish. No? These are the main fees that are going to pay. I'm going to abandon this and then move to show you the fees. Let me put it in a way that makes sense. I can close this, but anyway, I'll share. So this is the PCT tables, the fee tables. This is published on a monthly basis in the PCT newsletter that is in the PCT, in the JIPO website. The fees, it's themselves, the amount is, they don't change. What change is the currency, the different currency values, because you know the dollar one day is up, one day is down. So as the fees are in different currencies, they can change. You will see there is the first table is the transmittal and international filing fees. And all countries are listed with all the fees and all the international searching authorities that are competent for those countries. For instance, let's Belize here. Belize, the transmittal fee is, well, is Belizean dollars. I don't know if you are familiar with them. Let's look for one that have US dollar. Who has dollar here?
So
I'm trying to look for one that could be a good example. But this one, Djibouti, that is in Asia. The transmittal fee is $100. The international filing fee is, as I mentioned, $1,553. The fee for additional page is $16. And then they don't have fee reductions because they don't allow for electronic filing. which are the competent international searching authority for Djibouti, Austria, Egypt, and the European Patent Office. That's one example. Let me look for another example closer. But Trinidad and Tobago, here at the very end of this page. The filing fee, the transmittal fee is in TT dollars, 750. The international filing fee, the same in US dollars, 1,553. And they use as international searching authorities Austria, Chile, European Patent Office, Sweden, and US. See, they have 5 international searching authorities. This one here, that is Thailand, has 1, 2, 3, 4, 5, 6, 7 international searching authorities. There are countries like here, this is Slovenia, I think, only the European Patent Office. And so on. You see, there are many examples. This information is available free of charge in the international, in the JIPO website on their patents. This is the international filing fee. I'm trying to find a country with reductions to show you. You see, for instance, here US, that is in US dollars, obviously. The US, the transmittal fee is 260. But the US office has decided to grant fee reductions to small entities and micro entities, according to their legislation. The international filing fee the same. And then here you have e-filing reductions. This depending on the format of filing the international application. If you file the international application electronically in PDF, you will have a reduction. But if you file this same electronic international application electronically in XML, the fee reduction is going to be bigger and more important because it's easier for us to process this for the purpose of the publication. And here you see that US has also many international searching authorities. They have Austria, the European Patent Office, Israel, Japan, Korea, Russia, Singapore, and US itself. So 1, 2, 3, 4, 5, 6, 7, 8 international searching authorities. I would say the average is 2, 3, but you can have as many as the office decide. In this second table are the search fee. You may remember that I told you that along with the transmittal fee and the international filing fee, you will have to pay the search fee that is for the international searching authority. These 3 fees are paid to the receiving office, and it's the receiving office who will distribute the money among the International Bureau and the International Searching Authority. For instance, Austria, the search fee is here in dollars, 2,091. Australia is 1,697. Canada in US is 1,243. I can't see anything. Let me open a little bit. China is 309. Very cheap. The European Patent Office is 2,091 dollars, like Austria and like Spain, because all the European offices, they apply the same fee and the same fee reductions. And so I forgot to tell you something very important concerning the transmittal, the international filing fee. The international filing fee that, as I mentioned, is $1,453 can be reduced 90% if the applicant is a natural person for a country with a level of the Global National Product (GNP) according to the UN. I think Jamaica will benefit of this fee reduction. I'm not sure because as Jamaica is not in the PCT, we haven't checked it. But most of the Caribbean countries use this fee reduction. It means that applicants that, I repeat, natural person, not legal persons, natural person, uh, individual inventors that are national or residents in these countries will pay only 10% of the international filing fee. That means that you will pay 145 US dollars instead of 1,400. And that's very interesting for applicants from developing countries. This fee reduction can add to the fee reductions for electronic filing. So it's really can be really important. The search fees can be also reduced. As I told you, as every international searching authority established their own fee, every one of them also established their own fee reductions. In the case of Europe, the European Patent Office and all the European national offices, they, instead of using the UN classification of developing countries, they use the World Bank classification. And in this case, they apply a fee reduction of 70% for the legal and natural persons coming from the countries that can benefit from the fee reduction. These have to be checked carefully when trying to file an international application because selecting the international searching authority is also part of the strategy that you are going to use. If you have many authorities at your disposal, you are going to select the authority that can help you get in a better position the granting of the patent in your main market. For instance, if you export to US, you are going to be using the US PTO as International Searching Authority. So when you enter into a national phase, it's easier for you to get the patent granted because you know what they're going to say already. So this is something that you have to reflect on when filing an international application. As you see, this is in the JIPO website. If I go back, I went back to you type JIPO INT, that is our web page. If you go down, you will see the IP services. You go to patents, that is all the PCT information. You find all the information about the PCT, and then here, down here, you will find the fees. You see fees. There is the text of the treaty, the PCT applicant's guide, the ePCT portal, etc. Okay, so I'm going back to my previous presentation to continue. Okay, so we are at this point, the last stop, that is the entry into the national phase. Let's review a little bit what has happened with the international with this international application. You file your national application, then In 12 months, you file the international application, the PCT application. In 16 months from the priority date, you get the international affairs report and the written opinion. And 18 months, you will see the international publication happen. In 22 months from the priority date, you can request the supplementary international search or the international preliminary examination. You will receive these documents at 18 months. Remember that both of these are optional. And then the time goes by and we arrive to the month 30 from the priority date, and you have to decide the entry into the national phase. The entry into the national phase represents the aim and the end of the PCT procedure. You are, since the very moment you file the international application, you were looking at the national phase because your objective is to get patent protection in a certain number of countries. In the same way, the national phase represents the ultimate stop of the PCT procedure, and then the PCT will stop to be applied to the international application, and the national law is the one who is going to govern the international application, and you can see it here. All this gray area is governed by the PCT and the regulations, but once you enter the national phase, the substantive relevant provisions of the national law will apply. The PCT will no longer apply except for the issue of formalities. We try, member states, not to request more formalities than the ones that are already in the PCT. So in terms of formality, the PCT will survive the entry into the national phase, but in terms of patentability requirements, is the national law who will apply. And the national entry phase is decided by the applicant. No one is going to call you or send you an email telling you you have to enter, you have to decide entering or not in the national phase. That's the applicant who have to first monitor the timeline, and secondly decide beforehand, before the actual 30-month period, if he's going to enter the national phase or not, and where. So this is a list of decisions to be taken by the applicant. First, I'm going or not to enter in the national phase. If my sales report is a disaster, they tell me that there are many documents in the state of the art that are similar to my invention. Is the written opinion tells me that no way I will comply with the patentability requirements. So why I'm going to enter in the national phase? It's not good for my application because it's never going to get a patent, and it's not good for my pocket because when entering into the national phase, you have to pay the national fees that you have postponed all this time during the international procedure. So if I know that the potential of my invention is not good enough to deserve a patent, that a patent is not going to be granted, then I don't do anything. And just by the expiration of the time limit, the international application dies by natural causes. On the contrary, if I see that my invention has a value, has a possibility to be granted and be commercialized, then I will enter into the national phase. So it takes us to the next question. When I enter into the national phase? I have been mentioning all the time the time limit of 30 months, but you actually can enter the national phase anytime during the international procedure. And we see it very often these days because, as I say, There are fields of technology that are evolving so fast that applicants want to enter the national phase as soon as possible just to get some kind of protection because they know that behind them there are a competitor that are developing another product that will cancel this product that they are protecting because of the technical progress that is normal in these technological fields. So you don't have to wait up to 30 months to enter the national phase. That's the limit, the ultimate limit. But you can enter and you should enter the national phase before the 30 months period. The ideal moment to enter into a national phase to get some advantage of the PCT procedure is immediately after you receive the international affairs report and the written opinion, to have some technical background to support your decision of entering or not into the national phase. But let me tell you, there are applicants that file an international application, and even before they get the international affairs report, they are entering into the national phase because of commercial reasons that are pushing them to try to be present in a given market, in a given area. So they enter the national phase just to try to get the patent as soon as possible. And then the other important question is where I'm going to enter into a national phase. As I told you at the beginning, when we file the international application, we are filing simultaneously in 153 countries. That are going to be 154 when Jamaica joined the PCT. So in that case, you are hypothetically protecting your invention in those countries, but you have to confirm your interest in these countries by entering to the national phase. And well, that is an important decision to be made by the applicant because he has financial implication. As I said, you have when entering into a national phase, you have to pay the national fees. So it's not the same to enter into a national phase in 5 countries in terms of fees that you have to pay that to enter into a national phase is 100 of countries. The fees are going to be enormous. So you can get some kind of rationalization in the procedure using regional offices when available. For instance, instead of filing in every European country, you will file with the European Patent Office. The same happen in the countries that are the east of Europe and Asia. Instead of going to Russia, Belarus, Uzbekistan, Kazakhstan, etc., you will file with the Eurasian Patent Office, and then you save some money. In Africa, we have also JIPO and OAPI that are regional organizations. In America, we don't have any regional organization, so you will have to go country by country. These are the acts that have to be performed by the applicant when entering into a national phase. First and above all, the payment of the national fees. You know that the administration doesn't work if you don't pay the fees. That's common for every kind of procedure you want to do. So in that case, you have to pay the national fee in before or with the national office. Then you have to file, if needed, a translation of the international application, if in your case have not been filed previously in English. If it is in English, you don't need to file an application. The applicant have to know that every single modification that he has made to the international application is published in patent scope. So the national office has access to any changes that has happened during the international procedure. You can change your claims. You can change the descriptions. You can change everything. But you should know that the national office would know that you did it. So it's better to come clean, and when entering into a national phase, just to explain to the national office if there are big changes, the differences between the international application as previously filed and the national and this application that is entering the national phase. But that's up to the applicant. There are some cases that the changes are not that significant and there is no need to explain that. But in any case, keep also in mind that it's strictly forbidden by all patents laws all around the world to include new subject matter in the application. If you file something during the PCT phase in the international applications, you cannot add new matter when entering into a national phase because the office will know. Be sure, because all documents are available not only for the office but also for you in patent scope. Everything is published in patent scope. Just for the sake of transparency of the system, of certainty of the system. Everything is there. So don't try to fool the office because we are backing them with the information that is published. These are the requirements I told you. There are some national requirements. For instance, in US, the oath of declaration by the inventor, and in most of the countries, the assignment documents that you should also file if there is a need. In the case of assignment, if something has happened with the applicant, that is very common, by the way, that the applicant changed because enterprise merged, enterprise went to bankruptcy, and a new one succeeded, etc. If the applicant that is not in the international application is not the same that is in the application entering into a national phase, then obviously the national office will request explanations. This is not a requisite to enter into a national phase. They cannot tell you when you are filing, no, I cannot accept you the application because the name of the applicant has changed. No. But the following day, they will send you an invitation to correct or to explain and ask you why the applicant name has changed, and you will have to support this change with assignment documents properly signed, etc. That is something that happens again all the time because the international phase is quite long and a lot of things can happen, but this has to be explained to the national office. The translation of the priority document can be also requested, but only on exceptional cases. Most of the countries require the appointment of a local agent and the submission of a power of attorney that you have also to be very well aware, because that can be problematic if you don't plan it in advance, contacting patent attorneys in every country that you are interested in, and then filing through them, because that's something that is required by the national legislation. The international application itself does not need to be provided. When you enter into a national phase, you don't need to file a copy of the international application because it has already been published in patent scope. And if the national office needs to see it, they will go to patent scope and they should not ask you to give you a copy. But in some particular cases, mainly when there is a translation involved, the office can request a certified translation of the international application. The priority documents is the same if you if your application claim a priority from a previous application, you don't need to attach it when entering into a national phase, because you are supposed to provide it during the international phase, and if so, it has been published and is available in patent scope. We also publish the priority documents in patent scope. The translation again, in the PCT, the issue of translation is a big issue, because as you can see, we have 10 publication languages. But in your case, being English the national official language, I don't think it's going to be a problem for applicants in Jamaica, because you have plenty of options in foreign offices. These are, just to conclude, because I'm on time already, some recommendations for preparing the entry into a national phase. First, the applicant should leave sufficient time to prepare the translation if needed, and contact and give all the relevant information to the local agent in every jurisdiction, because the timelines in the PCT are sacred. If you don't enter into a national phase in the prescribed time limit, the national office can refuse the application. And all the efforts that you have made and all the payments you have made are lost in space, because just a deadline. So also be really aware to control the timelines in the PCT, and particularly to control the timeline for entering into the national phase. I don't know if you noticed when I show you the JIPO website, but there is a time limit calculator incorporated in the JIPO website that is free to use. So you input your priority date, your international filing date, and then the calculator automatically will tell you when the publication is due, when the international self-report is going to be established or should be established, and then when you have to enter into a national phase, when the time limit, what the time limit is for entering into a national phase. There is in some countries a system of payment of fees linked to the claims. You see that in the PCT, the payment of fee is linked to the number of pages of the application, not to the number of claims. But in certain jurisdictions, you have to pay not by the number of pages, but by the number of claims. That's something that you have to also to try to control, to cut down the fees that you will have to pay. In that case, you can merge claims just to avoid these fee claims. And again, the time limit is important. In the PCT website, you probably see that we have also what we call the PCT Applicants Guide. The PCT Applicants Guide includes information, all relevant information about entering into a national phase in every member state. That is the timeline, the fees you have to pay, if there is a special formality you have to comply with, etc. The average time limit for entering to a national phase is 30 months. Some countries have 31 months. Another country, in the case of Canada, I think they have more than 40 months, but you have to pay a fee. But for peace of mind, keep the timeline in 30 months and try to comply with it in this period of time to avoid problems. Because there are solutions in the PCT. In the PCT, you have solutions for absolutely everything. If you are if the postman gets sick and you don't receive a correspondence that it could be important, there is a rule in the PCT that says what happens if your postman is sick. Everything is planned, is foreseen in the PCT rule. And also, obviously, when you are unable to enter into a national phase for justified reasons, there are also solutions, but they are complicated and they are costly. So it's better to try to do things on time and just be in the clear for the procedure. And with this, I finish. I hope this has not been very boring for you. I know that the PCT is not, as I said, the most interesting and dynamic things. Actually, there are many lawyers that instead of saying patent cooperation treaty, they say pretty complicated treaty because are the same acronyms. But again, I hope that this is has been interesting for you and will help you to face. I hope again very soon the future dealings of Jamaica with the PCT. So thank you, and if you have any question, please feel free.
Thank you, Rolando. It has been a very good presentation. Every time I see one of your presentations, I learn something new. So it's very useful to me. So I thought I knew everything about PCT, but there's always something new to learn. One of the things that I was looking through the list of participants, and I noticed there were a few individual inventors that must be chomping at the bit to pay that 10% fee instead of the 100% fee. I think that is a very useful feature of the PCT that will encourage us to use the PCT as a nation. And I hope that that will add to the development and, allow Jamaicans to be exposed to the patent systems of the international patent systems. I think that is a very useful thing. And I think that's something that we've not developed over the years. So I'm happy to see that this is a feature that we can take advantage of in Jamaica. And I definitely look forward to that. Let's see. I'm trying to see if there are any questions.
So there was a question in the attendee chat, but it was already answered and
Okay.
recognized. So, but I
Okay.
don't know if somebody could have any question or comments or doubts or want to share their experience. I don't know. I'm open.
Well, I'm not seeing any more questions. I think it's very useful that we have these PCT webinars because PCT will be an integral part of the new legislation. And I think a lot of our applications will come through PCT. And I'm glad to see that there's also a role for the attorneys in the PCT. So it's not like there will be no role for them. There's always a role for the attorneys in the IP system. So I am happy there that everybody has a defined role in the intellectual property system. I know we've gone a little over the time, so I'm gonna ask if there are no other questions or comments. I'd like to extend my thank you to Mr. Hernandez for this comprehensive presentation. I think we were enlightened, and I think we will be following up, and I would definitely like to thank you again, Mr. Hernandez, for everything that you've done. It was always a pleasure to be here with you, and I think that we will definitely be here in the future talking about PCT. So thank you very much, Rolando. I bid you a good evening, and
Okay.
thank you very much. And everybody
Thank
else,
you.
thank you for attending. And I thank you for all your participation in this series. It's been very interesting. Thank you.
Thanks to all of you. Thank you and have a nice day and a nice holidays weekend.
I kept hearing talking.
Okay.
Apart from you.
Okay.
No one. So it was good. Not many people were doing something.
30?
Yeah.
As far number down.
Get me information services you Chantal Glynis.
Yeah.
Roland
25.
Love.
It was about 25. It was 31 when I was counting. We got mostly law firms again. Individual attorneys, some new attorneys.
When is the next one?
The next one is in May.
What was that? Pushing.
What? Who is still?